witness that testified before court are found, based on the evidence placed on record yesterday and the day before, to be credible, reliable, and truthful, and the court cannot find any bias, prejudice, or any motive in the evidence of any of the state witnesses to indicate otherwise. Mention needs to be made with regards to the evidence of Colonel Ngwadleka. Safe to say that he was a brilliant witness and had left no stone unturned. He had dotted every T and dotted every I. He had not made any mistake as far as the custody chain or the handling of the exhibits or the serial numbers contained. The court finds him, and all the above then as stated, credible, reliable, and truthful. However, the evidence of Colonel Ngwadleka during his testimony was checked in the working case file, which the defense had insight of. And with reference to the evidence of Colonel Ngwadleka, the court has placed the procedure regarding the evaluation of expert witnesses on record already. He meets the criteria. In fact, he exceeds the required criteria in his thoroughness, and he can be, or he is mentioned by this court to be not only an expert witness, but a super qualified expert witness. That is the conclusion regarding Colonel Ngwadleka. I've already dealt with the gear house and the admissibility. However, I want to emphasize that the further aspect regarding the laptop that was stolen and mentioned as a reason, the stealing of the laptop is a non-event. It does not affect the chain of evidence regarding the gear house. The gear house starts where it was confirmed by the employees that the hard drive was indeed depicting the correct footage they recorded. Thereafter, they cleared for space for future events. Therefore, the theft of the laptop is neither here nor there. It's not a factor this court needs to consider. Now, in dealing with the defense case, the following is placed on record during the evaluation. The evidence of Mr. Wood is noted and greatly appreciated by the court, including his extensive knowledge with regards to the provisions of Act 60 of 2000, and it is so acknowledged by court. With regards to Mr. de Klerk, as per the cited requirements already placed on record in the evaluation of expert evidence, and specifically with regards to, I emphasize, the personal knowledge of the subject stroke exhibit. He did not examine the cartridge or the said SPA 24914. Further, he had examined all the other firearms and rifles which are not relevant to this case. Therefore, it is noted, and that is the only finding I can make on those tests conducted. However, it needs to be noted that during cross-examination, the witness